Whoops, it cuts it off now. Oh, well. I'm taking off the defendant. I spelled it wrong anyway.
Okay, counsel, it's 9 o'clock straight up. I'm going to let the judges know we're ready, okay?
All right.
Your Honors, we're ready to start.
I lost my picture. Is that all right?
Mr. Hoffman, this is Beth Myers. Do you, we can see you. Can you see any of us?
No, Your Honor.
Um,
It might be something I did. I don't know.
I don't know either. Do you want a moment to see if you can figure that out, or do you want to participate knowing we can see and hear you, but also recognizing that you cannot see us?
Well, I could do that, or I could get out and come back in real quick, see if it's fixed.
If you'd like to try that, go ahead. Mr. Souter, will you let Mr. Hoffman back in when he comes back?
I'll just give it a try.
Okay.
Oh, there, I'm in. I don't know. I had something on top of the screen, so
All
I
right.
can see everything now. Sorry about that.
That's all right. Everyone's learning with the technology. We are ready to proceed this morning with the First District Court of Appeals. We have 3 cases on our docket. 1 is to be argued. The case that is to be argued is State of Ohio versus Zion Lyle. Counsel, I know you're both present, but if you will both introduce yourself, starting with Mr. Hoffman, and then indicate whether you're ready to proceed to argument.
Okay, I'm counsel for the appellant, David Hoffman. Lyle Zion is my client's name.
Thank you.
And John Vogt on behalf of the State of Ohio, ready to proceed.
Thank you very much. Mr. Hoffman, would you like to reserve any time this morning of the 15 minutes that you have for argument?
5 minutes for rebuttal, please, Your Honor.
All right. And whenever you're ready, you may proceed. And I will let you know when you're close to your time.
All right. Thank you, Your Honor. May it please the court, this is an appeal from a conviction from carrying concealed weapons charge. Can the court hear me all right?
Yes.
It's a little bit low, but
it's an appeal from a conviction on a carrying concealed weapons charge, and specifically it has to do with the allegation that my client failed to promptly notify the officer of his licensee status as a holder of a concealed handgun license. And this involved an unusual situation that began with a consensual contact, and it evolved into a detention.
So Mr. Hoffman, what is your position as to when the stop occurred with respect to your client?
Well, I take the position that when my client was ordered out of the car and got out of the car pursuant to that command, that constituted a detention, and that was when the stop took place.
So what was it before then? Was it just a consensual encounter? Is that your position?
Yes. I generally, when police encounter a parked car with occupants in it and they approach the car, it doesn't start out as a detention. It never does. Police can tap on the window, ask the occupant to roll down the window. They can engage the occupant in questioning, and none of that.
But does this? I'm sorry. Go ahead, Mr. Hoffman.
Well, I was going to say that none of that has to be justified. I think the law enforcement wouldn't want it any other way. And at some point, it becomes a detention when the officer starts to, I'll just use general terms, starts to boss the person around. If the officer gives commands to a person that he wouldn't otherwise give to a person that's not the subject of investigation, that's when it becomes a detention. But otherwise,
but does the statute require a detention in the technical sense of a detention?
It uses the term stop. And a stop is a form of a seizure. It's a form of a detention. And
But
it doesn't,
in layman's terms, isn't a stop any kind of encounter where an officer would stop somebody?
well, then
And isn't it used in that sense as opposed to a Terry stop that would require reasonable articulable suspicion? And I ask that because the purpose of the statute is officer and public safety. And if the purpose is to alert an officer that a citizen is armed, why does it have to be a detention and not simply a stop in the lay sense of the word stop?
well, if it did have that meaning, if the General Assembly intended it to be any contact at all, I think that it would be imposing a duty on license holders that non-license holders wouldn't have. I don't know that it would be, and it would be inconsistent with the idea of a consensual encounter also.
But they didn't, the General Assembly didn't use the word detain, right? They could have used that word as well, but they chose the word stop. And, you know, like Judge Myers is saying, if the whole point of the statute is for officer safety, shouldn't we read stop in a more broad sense since they didn't choose something like detain?
Well, they don't just use the word stop, they qualify the word. If you don't mind, it's a really short statute. I'd like to read it because I think when you hear the statute, it'll convey the meaning that I'm proposing. It says, no person who's been issued a concealed handgun license shall do any of the following. If the person is stopped for a law enforcement purpose and is carrying a concealed handgun, fail to promptly inform any law enforcement officer who approaches the person after the person has been stopped that the person has been issued a concealed handgun license. And so it repeats it twice. It says the person has to be stopped first. And it says that stop has to be for a law enforcement purpose. And so
But interviewing witnesses, walking up to somebody to ask them if they've seen anything, that's a law enforcement purpose, right? It's also a consensual encounter.
Yes. Well, yeah, but I thought, to me, I think that the person would be the focus of the investigation. The person is being stopped for a law enforcement purpose. I think that it means a detention. I think that they're using the word stop in the law enforcement.
So
I think
you're saying, I'm sorry, but Judge Myers, go ahead.
Go ahead, Judge Bergeron.
So you're saying that if it were an officer trying to interview a witness or question someone who saw something, that would not constitute a stop under the statute?
Yeah, that's the position I'm taking, because it would be a consensual encounter. And under the law, Fourth Amendment law anyway, there's no duty to, a citizen doesn't have a duty to do, it's consensual. It's a consensual encounter and there would be no duty.
Well, so are you drawing the line at whether the person is free to go? I'm just trying to understand your position.
If the words or behavior of a police officer would convey to a reasonable person that the subject is not free to leave under Mendenhall, then yeah, there would be a stop for a law enforcement purpose, and there'd be a duty to inform the police officer of the status of the licensee status.
What about a case where a driver is pulled over for speeding and they're pulled over? That's not consensual. And you would agree, I assume, that the driver of the car has a duty to inform the officer about the license and that there's a gun.
That is correct.
What about the passenger who is not being detained for any reason because the passenger wasn't driving, presumably free to go? Is it your position the passenger doesn't have to say, hey, me too, I've got a gun?
It would not be a stop of the passenger. the passenger would not be stopped for a law enforcement purpose, and therefore, yeah, the passenger would not have that duty under my reasoning.
Doesn't that totally disarm, pardon the use of words, but wouldn't that be totally contrary to the purpose of the statute, which is to alert the officer that in a car that's pulled over, there may be a gun?
I don't think so, because the focus of the officer would be on the person being detained, and the risks would primarily come from the person being detained and the focus of the investigation and not a passenger. That would be my response.
All right, thank you.
With regard, Mr. Hoffman, with regard to the promptly inform piece of this, if we were to accept your argument that the stop occurred when he was seized, when he was taken out of the car and placed in handcuffs, that's when you're saying the stop occurred in this case, right?
That's correct, yeah.
Isn't the evidence that the officer that seized him, that he did not inform the officer that seized him about the gun until he was seized at 3 minutes and 15 seconds?
That was the testimony at the trial. And, you know, I apologize to the court for not picking up on this, but in State's Exhibit 2, the video, there's a point where my client's being interviewed by the officer, Sarche. And a statement was made, and that my client had actually informed the deputy that was watching at the window of his licensee status prior to being removed from the car. The time marker is 1:50 to 1:51. And so it gets even better than that. I mean, he's removed from the car and he gives notice. In my position, he gives notice when he's removed from the car, which is at the point of his detention. But that video indicates that the notice was given before that time while he was still seated in the car.
And the officer who was at the window, presumably talking with your client, did not testify at trial, did he?
No, he did not.
And Mr. Hoffman, you have 1 minute left if you want to reserve 5.
All right, thank you, Your Honor. I think that this statute being a criminal statute, it's composed of elements. Elements need to be strictly construed and they need to be proven, each element in a crime. And one of the elements in this crime is that the failure to disclose licensee status has to be done in the context of a stop for law enforcement purposes. And our position is that the stop did not take place until there was a command for my client to get out of the car. And at that time, notice had been given, or either before that or immediately thereafter. And so I'm arguing that there was no violation here, and I'd ask that this court would reverse for failure to prove all the elements of the crime.
All right, thank you, and you will have 5 minutes left.
Thank you.
Mr. Vogt?
Thank you, Judge Myers. So Your Honors, this case boils down to just essentially what stop for a law enforcement purpose means. And in a light and most favorable to the state, under that standard, we think the fact show the definition was satisfied. And as we've talked about, stop is not defined. And to your question, Judge Myers, I think a consensual encounter is a type of stop. And Judge Krause, to your question, the General Assembly, I had that in my notes, they could have said investigatory detention or even Terry stop or something more specific regarding a detention, but they did not.
Mr. Vogt, are you saying that if I'm standing kind of on a street corner and there's a parade going on and the officer comes up and just says, hey, have you seen anything amiss going on in this parade, and I've got a concealed carry, that at that moment I must inform the officer that, hey, by the way, I've got a concealed handgun?
I think so, Your Honor. I think questioning people about crimes, although that example is a little more general, but questioning people about crimes that have occurred is a law enforcement purpose based on the plain language of the statute. And while that perhaps be little different for that scenario. I think that is inclusive under the broad language.
I
of
mean,
the
because
statute.
the risk with your interpretation is that anytime anyone who has a concealed carry comes in contact with a police officer, they risk a conviction under the statute. They don't immediately divulge that, even if it's ambiguous as to whether or not a stop is occurred.
Well, I think I respectfully sort of distinguish that just a little bit, Your Honor, that I think that a person that comes into contact with the police, if the police approach them, and the statute talks about an officer approaching someone for a law enforcement purpose, I think there's a difference between people coming into contact with police working, details on Fountain Square than an officer approaching a specific person and asking them a question for initiating an actual consensual encounter, as was the case in this case where the encounter was specifically about gunshots.
But what about, so I think we all agree that the purpose of this statute is for officer safety. So that an officer
I'm
that-
sorry, judges, if one of you is asking me a question, my screen, I think that might be you, Judge Krause, my screen, you're all frozen.
You're frozen.
Oh, geez.
We can
We
still hear
can
you.
hear you. We can hear you.
Can you hear us?
Can I leave and come right back? I'm sorry, Your Honors. I can't. Everyone's still frozen.
Yes, and I will stop the time right now.
It's fine,
Your
you're
time
good
right
now.
now.
We
You're good now.
can see you now, Mr. Vogt.
You're not frozen anymore.
I'm going to use the chat really quickly.
You're
I don't
okay,
think he
Ron.
can hear us. Can you hear us, Mr. Vogt?
Yes, he wants to leave and come back. So
Oh,
go ahead and do that.
Yes.
Oh, I think he's waiting for somebody to chat
Oh, yeah.
back.
All right, I'll do it.
Okay, I think can everyone hear me?
Yes.
I'm extremely sorry about that, Your Honors. My apologies. Someone was in the middle of asking me a question. I couldn't hear who.
That was me, and don't worry, that actually happened to me in the middle of an argument too. So, no, my question is: we all agree that this statute is for officer safety, so that a police officer knows that he's dealing with somebody that's carrying a weapon or a gun. But I guess my question is, if we interpret the statute as broadly as you want us to, and we say a stop is a consensual encounter, then it would only apply, according to your interpretation, if a police officer walks up to somebody and quote unquote stops them. But if somebody walks up to a police officer, say they witnessed a crime and they walk up to a police officer, the police officer didn't stop them, and they say, hey, I just witnessed a mugging up the street, then under your interpretation, they would not have to disclose that they had a gun. So it just seems kind of odd, right? The only way it applies is if the officer initiates the contact.
I think that, that is the distinction I am making, Your Honor. I don't see that as problematic based on the language of the statute, but I understand your question. I think certainly in the facts of this case, when you have an officer asking someone about, hey, have you heard anything about gunshots, and they have a gun, it would seem to be sort of an absurd result under the officer safety goal of the statute to say that that person's under no obligation to divulge that they have a weapon at that time.
So, Mr. Vogt, let me ask you a record-based question. In watching the video, at about 45 seconds, the defendant rolls down the window, and the officer at that point says, "Hey, does anyone hear gunshots?" Then he asks the driver to step out of the car. That happens about 1:15. The next thing, then there's the whole incident with the driver getting arrested. The officer comes back to the car at about 3:15 to extract the defendant. And when he interfaces with the officer that's at the window, that officer says he's got a gun or something to that effect at 3:15. So all we know from the video is that between 1:15 and 3:15, the defendant apprised the officer at the window that he had a gun. And so in light of the fact that that officer didn't testify, let's assume you're right on that a stop occurred the moment that the officer knocked on the window. How has the state met its burden to show that he did not promptly inform the officer of the existence of the weapon?
I think so. That sort of goes to my fallback argument that even if Mr. Lyle was under no obligation to respond to Officer Sarche when he asks him, have you heard anything about gunshot? If you also, the record contains Officer Sarche testified on page 12 of the transcript that it was a drug investigation at that point. He further testified on page 27 of the transcript that he was suspicious of both of them. That I think as Officer Sarche was ordering the driver out of the car, I think certainly at that point, Mr. Lyle had an obligation to tell Officer Sarche that he had a weapon on him.
But this is the factual problem. That officer then immediately leaves to deal with the driver. And we don't know on the record whether or not the defendant immediately told the officer at the window, hey, by the way, I have a gun. I mean, there's a gap in the evidence to show us when that happened. And so from a factual perspective, if that was a stop and he immediately told the officer, then I think he's complied with the statute. If he waited 2 minutes, then I think it's a maybe not. But I think that's what I'm struggling with from once we get past the theoretical issue about when a stop occurred to like what happened here on this record.
I see your point, Your Honor, and I would just say that I'd stick to my guns on the, no pun intended, on the first argument that he was under an obligation under a consensual encounter to tell an officer that he had a gun, asking about guns. But even under part 2, shall promptly inform, and promptly can be defined as immediately, that he had an opportunity, albeit a short one, even though Officer Sarche does quickly thereafter leave and talk to the driver, that there was a moment or two there that he could have told Officer Sarche. And I agree, the other, we do not have, obviously, I think it was a deputy that was told to watch the window by Officer Sarche. So that is perhaps something a little inadequate with the state's position.
Back on the issue of stop. So I guess trying to define stop, I mean, you're defining it as consensual encounter, but pretty much when you look at the law, stop is used with regard under, interactions with police officers with regard to an investigatory or Terry stop. That's when we see the word stop being used. So why shouldn't we interpret the statute, the word stop in the statute, stop for law enforcement purposes, to equate to at least an investigatory or Terry stop situation?
I think that would have required more specific language, and there's nothing ambiguous about stop for a law enforcement purpose. I think the flip side of that would be similar questions. Well, is investigating gunshots, is that not a law enforcement purpose? If not, how do you qualify that? So it would seem that the language itself is unambiguous and covers a broad spectrum of activity, that although, yes, we do frequently hear the phrases Terry stop or investigatory detention, those are specific terms that the General Assembly could have used but didn't. So unless there are any other questions, I think a stop for investigatory or stop for law enforcement purpose certainly covers questions about gunshots consensual encounters initiated by the police, and certainly in the facts of this case, that's what occurred. And then based on Officer Sarchet's testimony, it transformed into an investigatory detention under which Mr. Lyle was obligated to disclose the handgun and failed to do so promptly.
Thank you, Mr. Vogt.
Thank you, Your Honors.
Mr. Hoffman, you have 5 minutes.
Thank you, Your Honor. With respect to the video and the evidence of disclosure by my client to the deputy, although the deputy didn't testify at trial, the statement of Officer Sarchet that the disclosure was made to the deputy, it was admissible because it would be an admission of the defendant. I mean, that was in the context of that statement was post-arrest interview by Officer Sarchet, where he reviewed with my client, where he obtained statements from my client, and he obtained my client's assent to the factual scenario where that notification was given to the deputy about 1 minute in. And that would have been admissible at trial if it had been, I mean, the whole exhibit was admitted, so it's in evidence.
Wait,
I mean,
I'm confused. You're telling me that there was evidence presented at trial that your client disclosed to the deputy at the window at 1 minute in about the gun?
That's what was conveyed. I'll read, it doesn't take long. This is Officer Sarchet talking to my client when he's got cuffs in the backseat of the police car.
Okay.
When I asked you to roll the window down, you did not bring up the CCW. You did not tell me there was a gun. I got your friend out, did all that. As the deputy's talking to you, probably a minute in, you mentioned that you had a CCW. And that was part of the admissions that he elicited from my client. And that would have been admissible if they really tried to get it in front of the court. But like I'm saying, it was in the exhibit, and the exhibit was in the
Oh, it wasn't presented at the trial.
It wasn't pointed out at the trial.
Okay.
But the exhibit was admitted at the trial.
Okay.
Nobody brought it up. I mean, it doesn't contradict anything. It just adds to it. I mean, the specific questions that were asked were answered truthfully. It's just that nobody asked this question.
Okay.
The other thing is, I'm not sure how much time I have left, but
3 minutes.
okay.
3 minutes.
If you're going to interpret stop broadly, then whenever somebody gets a license, they ought to waive their Fourth Amendment rights, because people have a right not to talk to police officers if they're not in detention. But that won't be true with license holders now. They're going to have a duty to show their papers whenever they come into contact with a police officer, whether it's an investigative stop or not. And I don't
under the state's interpretation, it's only going to be when the police officer approaches them or stops them. So it's not whenever they come in contact with a police officer.
Well, that brings me to my last point, and that this question's been answered already in Strongsville versus Johnson. In that case, there was a stranded car. The motorist ran out of gas, and he was in the median. The car was not registered to him. It was registered to his wife. A police officer comes up. He was a license holder, and they asked if he needed any help or anything. And when he asked for the guy's license, because it wasn't his car, he refused to give the police officer's license. There was a big back and forth about this. I mean, it became a big deal, but he never revealed his CCW until they found out that he had the license. But the police officer found out, and he was charged. And the Court of Appeals said that it was not a stop, that he didn't have a duty to reveal his licensee status, because it was not a detention at first. It was a consensual encounter, and it has to be a stop. And so if you hold otherwise, I mean, it'll be a direct conflict with that Johnson case, because
that's the 8th District decision.
That is correct, Your Honor.
And there was a strong dissent in that case as well, right? Criticizing the majority for their narrow reading of the word stop.
You got me on that one, Your Honor. I guess I didn't read that.
Pointing it out.
Okay. That's all I have to offer for the court. And again, I'd ask that this court would reverse and discharge for lack of sufficient evidence. If there are no further questions.
Questions? No. Mr. Hoffman, Mr. Vogt, thank you both very much. We will take the case under submission and give you a timely written opinion. That will conclude our oral arguments this morning for the First District Court of Appeals.